Truth and nothing but the truth.
I do.
All right, thank you. Ms. Gutierrez.
Thank you, Your Honor. Ismar, who do you work for?
I work for the Texas Department of Family and Protective Services.
And what do you do for them?
I'm an investigator for them.
Okay. And were you in that role with the department back on, let me see here, September 21st of 2024?
Yes.
And is that when the department received a report regarding domestic violence between Sarah and Hunter?
Yes, ma'am.
Okay. And can you identify the children that were involved in that intake?
Yes, it was Avonlea Hammonds, William Smith, Stetson Gordon, and Josie Gordon.
Okay. And who was the mother of all four children?
My report has Sarah Gordon, but I believe she's also Sarah Smith.
Yes, ma'am, that's correct. And who is the father of Avonlea Smith?
Of Avonlea Smith, we had listed as Dakota Hammonds.
Okay. And if his rights were found to be terminated previous to the investigation, would that be correct?
Yes.
Okay. Now, regarding the other three children, who was their father?
Hunter Gordon.
And based on the intake, or rather, can you tell me what the intake was?
Sure. The intake talked about concerns of domestic violence between Ms. Gordon and Mr. Gordon with the children present.
Okay. And based on that intake, did you make contact with Avonlea at her school on September 23rd of 2024?
I did.
And what did Avonlea state during that interview about any abuse or neglect?
During her interview, she talked about witnessing domestic violence between her mother and her father.
And
There's
forgive me for interrupting. Who did she identify in her household at the beginning of the interview?
All right, guys, buckle up because this case opens with a tone that tells you immediately this is not routine. Within seconds, the oath is given, the witness is sworn, and the authority of the courtroom takes over. There is no small talk, no warm-up, just straight into sworn testimony. The investigator's role is established clearly, signaling that what follows will carry serious legal weight. This short opening sets expectations. This is about child safety, government intervention, and decisions that will permanently change lives. The calm delivery contrasts sharply with the gravity of what's about to be revealed, drawing viewers in before they even realize how deep the case goes.
It would have been her grandmother, her grandfather, her mother, and her father and her siblings.
And when she said her father, did she specifically state Hunter?
Yes, ma'am.
So though Hunter is not her biological father, in her interview, she refers to Hunter as dad and father. Is that correct?
Yes.
Okay, thank you. Now, if you could continue sharing what statements the child made about abuse and neglect, please.
Yes. So in her interview, she did make a outcry regarding domestic violence between them. She reported her mom and dad hitting each other, causing the dresser to fall over and hit her and her brother on the head.
Okay. And following that, did she make statements about her dad getting into a fight recently?
Yes, she did.
Okay, and what statements were those?
She talked about her father getting into a fight with a friend, and talked about her mother being present.
Okay. And in addition to that, did she talk about a dresser being a part of some kind of altercation as well?
Yes, that would have been with the first altercation she had talked about,
Okay.
regarding the dresser falling on her and her brother.
Okay, thank you. Now, after interviewing the child, did you also try to interview the mother on September 23rd of 2024?
Yes,
Okay. And after some back and forth, you were able to meet with her at her home. Is that correct?
correct.
And did she deny the allegations?
Yes, she did deny the allegations.
Okay. However, you also spoke with her mother. Is that correct?
Yes,
And let me rephrase. The mother or grandmother of the children is Jennifer Smith. Is that correct?
correct.
Okay. And did Jennifer Smith confirm that there was physical fighting between Hunter and Sarah still?
Yes, she did.
Okay.
Alright guys, this is where the case turns emotionally heavy. The testimony shifts from procedural facts to a child's lived experience and everything changes. You hear about a school interview, a safe place where a child finally speaks up. She describes violent fights, parents hitting each other, furniture falling, and children being physically struck in the chaos. What's striking is how casually the child refers to this violence, showing how normalized it had become. Even more telling is her calling Hunter dad, revealing emotional bonds that complicate everything. This moment establishes real harm, not speculation, and it becomes impossible to ignore the danger inside that home.
And there had been a previous FBS case earlier that year, is that correct?
Yes.
And when that case closed out, was part of that case to address domestic violence as well?
Yes, ma'am.
All right. Now, with you understanding that there's domestic violence in the household, did you put in a safety plan?
Yes, I did.
Okay, what was the safety plan?
The safety plan was that Miss Gordon was not to allow Mr. Gordon back into the home and that she would have to be supervised at all times by her mother
Okay.
while
And-
around the children.
And was the case evaluated for whether or not it was appropriate for the Texas Families First or the Family-Based Safety Services program?
Yes, it was.
And briefly, those two programs are, they can involve legal intervention, but they don't involve removal of the children. Is that correct?
Correct.
Okay. And were both parents upset about the safety plan?
Yes, they were.
And when I say that, I mean specifically Hunter and Sarah. Were they upset about that safety plan?
Yes, ma'am.
Now, can you tell us about some of the some of the CPS history that Hunter and Sarah have?
Sure. Miss Gordon worked services through our family-based safety services program 3 times for concerns of domestic violence. She did not complete, I'm so sorry, Mr. Gordon worked services 3 times through our FBSS program and did not complete his services in 2 of the 3 cases. And then he also worked another FBSS case in 2019 for domestic violence regarding a different partner.
Alright guys, pay close attention here because credibility is tested in real time. The mother directly denies the allegations, attempting to shut down the narrative of violence. But almost immediately that denial is undercut. The grandmother steps in and confirms that physical fighting between Sarah and Hunter was still happening. This isn't hearsay or rumor, it's coming from within the household itself. The courtroom tension spikes because the story no longer rests on a single perspective. When a close family member corroborates the violence, the case gains weight fast. From this point forward, the department's concerns no longer sound hypothetical, they sound urgent.
Miss Gordon completed, she had worked family-based services twice. In one of them, she didn't complete services, and in the second one, she did. She also has history of a removal of Avonlea back in 2017. Although she did complete her services then and was reunited with her daughter in 2016.
And so what role did that CPS history play when the department evaluated whether or not the FBSS or the Texas Families First programs would be appropriate?
The department felt at that time, due to the multiple reports that we had received with the family, due to the fact that they had worked services with the department several times, regardless of that, we still continue to receive reports of domestic violence. So we felt that both of those programs would not be appropriate for the family at this time.
Did the department seek out a court approval or an order before removing the children?
Yes, we did.
And was that granted?
Yes, it was.
Okay. And with both Sarah and Hunter, I apologize, with Sarah being the only legal parent to Avonlea and also being the alleged perpetrator in the case, would a kick-out order of her from the home have solved the problem?
No, it would not have.
All right. And as well, it sounds like the children would have continued. Is that correct if the case had gone through FBSS?
Yes.
Okay. And a parent-child safety placement, that was inappropriate as well because that would have put the case in an FBSS program. Is that correct?
Correct.
All right. Did I already ask you to name the department's reasonable efforts to avoid removal?
I don't believe so.
Okay. Can you tell us what the department's reasonable efforts to avoid removal were?
Yes, we had put in our safety plan stating that Miss Gordon was not going to allow Mr. Gordon back into the home, as well as being supervised by her mother. We also talked about the family-based case and the TFF case, and
All right, guys, this is where the history catches up to the present. The department lays out years of CPS involvement, repeated service plans, and repeated failures to change behavior. Multiple opportunities were given, yet domestic violence reports kept coming. The court hears that services were not completed, safety plans were ignored, and previous interventions did not stop the cycle. This isn't a one-time mistake, it's a pattern. That pattern is exactly why less drastic options like FBSS were ruled out. The testimony makes it clear that removal wasn't rushed. It was the final step after every other option had already failed.
ultimately, we decided that those two things were not appropriate, and we needed to look for receiving an order to remove the children.
Pass the witness.
All right, Mr. Michelson.
Thank you. No questions, Your Honor.
All right, Ms. Wiggins.
No questions, Judge.
All right. All right, Ms. Gutierrez, any other witnesses?
Yes, Your Honor. We ask if Miss Isamar can be released, though.
Sure. Ms. Pineda, I'll
Thank
go
you.
ahead and release you so you can go about your afternoon's business. Thank you for your testimony.
Thank you, Judge.
Thank you.
Okay. And Your Honor, we ask for judicial notice of that relinquishment signed by Sarah Smith, also known as Sarah Gordon, filed on November 19th of 2025.
All right, so noted.
Thank you. And the department calls Nerdy.
Okay. Ms. Angriani, you were sworn in their last case, so you're still under oath. Ms. Gutierrez, you may proceed.
Yes, Judge.
Thank you, Your Honor. Nerdy, who do you work for?
St. Francis Ministries,
And what do you do for them?
permanency specialist.
What are the duties of a permanency specialist?
We are having duty to find a permanency placement for the kid, as well as working with the parents towards their service plans, court order service plans.
Okay. Now, when you create a service plan, is it tailored to the issues in the case?
Yes, ma'am.
And in this case, did you create a service plan for Sarah?
Yes.
And was that service plan reasonably tailored to the issues surrounding removal?
Yes, ma'am.
Was it the department's reasonable effort to reunify the family?
Yes.
And can you name one or two services that was unique to the issues that Sarah was having?
I'm sorry, ma'am. Can you please repeat?
Can you name one or two services that were specific to the issues Sarah was struggling with?
Yeah, Sarah was referred to the WAVE class for the domestic violence, parenting class, rational behavior therapy class.
Okay. And Your Honor, we asked for judicial notice of that status hearing order.
So noted.
All right. Nerdy, did you make attempts to help Sarah complete her service plan?
Yes, ma'am.
Tell me about those attempts.
I refer Sarah to all the court order services, the parenting class, and also one time I try to provide a transporter. If Sarah doesn't have a transporter as well, I requested a transporter. And also I'm paying for the drug screen and also random drug screen and monthly.
Okay. And was Sarah having issues with drug use during the case?
Yes, ma'am.
Can you tell us about that?
She was she was found positive towards the end of the case, sometime around August, that she was positive with cocaine.
Okay. And during the case, did she continue her relationship with Hunter?
Alright guys, this section explains why reunification collapsed completely. The service plan sounds reasonable on paper, but the execution falls apart. Drug use enters the picture with a positive cocaine test. Then come the relationships. Reconnecting with Hunter and becoming involved with another man identified as a registered sex offender later arrested for murder. Each choice compounds the risk to the child. Key services like anger and violence counseling are left unfinished. At this point, the department isn't guessing about danger, it's documenting it. This testimony shows how personal decisions, not bureaucracy, ultimately sealed the outcome of this case.
She was actually not with Hunter at that time for a while, but then the month of when Hunter was arrested, I was told by Mr. Gordon that they were together again.
Okay. And what month was Mr. Gordon arrested in?
In early December. 1 second, ma'am. I'm not sure the date. 1 second. I think it's that is Smith. 1 second. Okay, November 18 is when Mr. Hunter. No, November 12th is when Mr. Hunter was booked into Randall County Jail.
Okay.
And so I just know the information from Mr. Gordon that they were together.
Prior to Mr. Gordon, was she also involved with another young man with criminal problems?
Yes, ma'am.
Okay. And what was his name?
I believe it's John Kemp.
All right. Your Honor, at this time, we offer petitioners exhibit number 2. Let's see. It's the sex offender search results on Mr. Kemp.
Any objections?
No objection.
All right, petitioners 2 is admitted.
Thank you, Your Honor. We also offer petitioners exhibit number 1, that positive screen for Sarah from August.
Objections?
No objection.
All right, petitioners 1 is admitted.
Thank you, Your Honor. Now, Nerdy, can you tell us what issues or concerns the department had about Mr. Kemp?
Alright guys, this is the moment everything leads to. Recommendations are made, placements are confirmed, and the judge delivers the final ruling. The court finds that termination of parental rights is in the child's best interest, based on evidence, testimony, and the signed relinquishment. The grandmother's home is affirmed as stable, and the department is named permanent managing conservator. There's no drama in the judge's voice, just certainty. This calm delivery underscores how thorough the process was. The case ends not with anger but with finality, a child's future legally redirected towards safety and permanence.
Mr. Kemp was a sex offender. And also, what I heard from Miss Sarah Smith was that he was involved in murder to one of the family member that he has. That's as far as I know.
Okay. And was he arrested for that murder shortly after that?
Yes.
And for clarification, that was a relationship she had during the CPS case. Is that correct?
Yes.
Okay. Did Sarah finish her services?
She finished some of the services, but not all of the services.
Thank you. Which services did she not finish?
The WAVE class and the individual counseling.
Okay. And that WAVE class stands for Women's Anger and Violence. Is that correct?
Yes, ma'am. That's correct.
All right. Now, Sarah has signed a relinquishment. Are we asking the court to terminate her parental rights solely on that relinquishment?
Yes, ma'am.
Do you believe that's the best interest of Avonlea?
Yes, ma'am.
Okay. Can you tell us why it's in the best interest of Avonlea that Sarah's parental rights be terminated?
Avonlea is still having what do you call it? I'm sorry. Trauma of that mom is still going to be with dad and having a domestic violence. She couldn't forget about what happened. Still, when I visit her every month, she's still trying to communicate on those worriness, and she's traumatized with what event that Sarah Smith created with Hunter.
Do you believe that Sarah's drug use makes her an unsafe person to take care of Avonlea?
Yes, ma'am.
Do you believe that she is unable to provide for the physical and emotional needs of Avonlea?
Yes, ma'am.
Do you believe the department should be named Permanent Managing Conservator of Avonlea?
Yes, ma'am.
Why is that in the child's best interest?
It's at this time Avonlea is living with the grandma, and that's the best interest.
Okay. And so is grandma's plan to adopt Avonlea in the future?
Yes, to be permanent. Yes, ma'am.
Okay. And for that to happen, the department would need to be named Permanent Managing Conservator today. Is that correct?
Yes, ma'am.
Can you please describe the department's reasonable efforts to reunify the family in detail?
Department is creating a service plan for Miss Smith, and also tailored to the situation. And then department also send a random drug screen to Miss Smith, and we also pay for that, and created and attempted to provide a visitation, so then Miss Smith can be bonded with Miss Avonlea.
And what about placing her with her siblings? Is that also?
Yes, placing her with the siblings and also with family.
Okay, pass the witness.
Mr. Michelson,
No questions, Your Honor.
Ms. Wiggins.
No question, Judge.
All right. Ms. Gutierrez, anything further from the department?
Nothing further, Your Honor. We ask for a finding of reasonable efforts of having tried to reunify the family and that her parental rights be terminated solely based off that relinquishment.
All right. Thank you. Mr. Michelson, did you have any witnesses?
No witnesses, Your Honor.
Thank you. Ms. Wiggins, recommendations?
Thank you, Judge. I do recommend that the parental rights of the mother be terminated for Avonlea. I do believe that's in her best interest, and for her placement to continue, she's doing very well with the grandmother and her siblings.
All right. I just wanted to know for myself, be sure I'm correct. All four of these children involved in these two related cases, they're all placed with, are they placed with Mr. Gordon's mother?
They're placed with
No.
mom's mom.
Okay. All right. Ms. Smith's mom. Okay. Good.
Yes, sir. They're all together. Yes.
All right. I thought that sounded a little strange. I wanted to be sure we covered that. Okay. All right, then. Then if there's nothing further, then based on what I've heard, as well as the exhibits that have been admitted, I do find that it's in the best interest of the child, Avonlea Smith, that the parental rights of the mother, Sarah Smith, also known as Sarah Gordon, be terminated. I'll terminate those rights today based on Texas Family Code, section 161.001, subsections B1K. I do find that the affidavit of relinquishment is on file in this case. I'll name the department permanent managing conservator, continue Avonlea's current placement. I will continue Ms. Wiggins with the Randall County Domestic Relations Office in this case as Avonlea's attorney ad litem. I will order that all other court-appointed relationships will be dismissed after all appellate and de novo periods have expired. Mr. Michelson, if you talk to Ms. Smith, advise her of her appellate and her de novo rights.
I will, Your Honor.
Thank you. All right, I'll set our first review hearing in this case for March 2nd, 2026. That will be by Zoom like today's hearing, so parties that are left can go on the court's online docket a day or two before March 2nd to see what time the hearing will take place so you don't sit around in the waiting room. So, all right, yes.
Are Are you also granting the findings of reasonable efforts?
Yeah, I do. I will find reasonable efforts made on the part of the department to reunify Avonlea with her mother. So, okay, this was our last case. We'll stand in recess. Everybody have a good rest of your week.
Thank you, Judge.
Thank you.
Sorry, I had to change to my phone. My computer died.
Okay. All right.
Thanks.
See y'all.